Hello, my name's Kate Redshaw, and I'm a senior lawyer in the employment team at Burgess Salmon, and I'm delighted to be joined today by my colleague Hugh Cook, and Hugh is a fellow employment lawyer. And Hugh, we're here to talk about Brexit and the implications for employment law. And of course, many people would have hoped that they could hear a little bit less about Brexit after the deal was struck on Christmas Eve last year. But of course, the consequences of the ending of the transition period and the deal itself mean that people will have questions. As we know, when we were members of the EU, UK employers were affected not just by EU laws, for example, the working time regulations are EU derived, but also, of course, EU case law has had a big impact on UK employers over the years. For example, the calculation of holiday pay springs to mind. So I'd like to focus our discussion today on what the deal means for UK employers in terms of any continuing obligations from existing EU legislation and case law, and when and how we might be able to deviate from that, and also to what extent we will need to follow the EU if they introduce new regulations or legislation and give further case judgments. So that's what I'm aiming to look at today, Hugh, but perhaps first we could just recap on what the transition period was and what it means now that it's come to an end.
Thanks, Kate. Yeah, of course we can. Well, cast your mind back to the 31st of January 2020, before COVID. That was when we left Europe and entered the transition period, which in real terms didn't change anything. We continued to be bound by European laws and case decisions. Transition period, as you know, came to an end 31st of December last year, when we had that mad scramble to get a deal done. And that deal formally is encapsulated in the Trade and Cooperation Agreement, TCA for short. And it's the TCA which sets out and navigates our future relationship with Europe.
Okay, and it's not for the faint-hearted, Hugh, I don't think, that agreement, is it? It runs to about 2,000 pages. But as luck would have it, Hugh, you're ready, willing and able to do the heavy lifting for us on that and turn those 2,000 pages into something a little bit more digestible for our viewers. So firstly, can we look at what happens to legislation now that we've left the EU? And in particular, can we start with what happens with existing UK legislation that's derived from EU directives? So, for example, we've got TUPE, we've got the collective consultation regulations in relation to redundancy, and as I mentioned earlier, the working time regulations. Are we still bound by those laws?
Simply put, yes, we are, because what happened on the 31st of December last year, the end of the transition period, was that we took a snapshot of existing domestic legislation, whether that was derived from European law or not, and that's what we've got going forwards. That's our baseline legal position, unless and until Parliament and the courts change that.
Okay, so what you're saying is that for now we continue to be bound by the existing EU-derived legislation and case law as it was pre-1st January this year?
Yep, that's right.
Okay, well, there's more I want to talk to you on about that and what that actually means, Hugh. But before we do that, can we talk about new EU law and new case decisions? Because, of course, the EU is going to continue to make new laws for implementation by its member states. And the CJEU, or the ECJ, the European Court of Justice as it was formerly known, will obviously continue to deliver case judgments. So to what extent, if at all, are we in the UK going to be bound by those new developments?
Well, Kate, the TCA provides that with effect from the 1st of January this year, the UK no longer has to implement any new EU directives or regulations. We can, if we want to, put in place laws that are similar or reflect future EU employment laws, but strictly speaking, we don't have to do that. That said, as you might expect, given the complexity of the negotiations and the deal that has been done, there are rules in the TCA which limit to some extent the way in which our laws can diverge from European employment laws going forward, and our employment laws may need to keep up, at least to some extent, with future EU employment law. And also the TCA limits, again, to some extent, the way in which we can change our laws, that snapshot that I was talking about at the end of the transition period.
Are you going to tell me this is something to do with the so-called level playing field?
Well, I know you're a sports fan. It's got nothing to do with that. You're right that we had a lot of talk about the level playing field in the run-up to the deal done at the end of last year. And what that really derived from was the EU being concerned that the UK might gain some kind of competitive advantage over member states by, for example, weakening our own employment laws or keeping our laws in place while Europe strengthens its laws and getting some kind of competitive advantage. And there are rules built into the TCA to try and guard against that. So, for example, the UK can't, and actually neither can the EU, weaken or reduce the employment rules that were in place at the end of the transition period in a way that affects trade or investment. So again, that level playing field piece. And that also includes failing to enforce our laws and standards. And there are also rules that are more forward-looking. This divergence issue that I touched on, we can't have any significant divergence from EU laws in the future.
Okay, so I know this is very complex, Hugh, so, in a nutshell, if you can, what happens if we do weaken our employment laws, or if these significant divergences, so-called, emerge?
Yeah, you're right, there's a lot of complex detail and procedure around this, but as you might expect, there are teeth if you fail to comply with what you've signed up to. So broadly speaking, you initially have discussions and consultations to see if you can resolve the issue, but ultimately the EU could take retaliatory measures against us, and that could include tariffs being imposed on the UK.
Okay. So how will we know, though, if a change actually does affect trade and investment?
Well, that's a very good question. We're obviously in uncharted territory. There's no precedent as to how you interpret that, nor guidance at the moment as to whether a change will affect trade or investment. Obviously, we could expect the EU to argue one position and the UK to argue the other, and we'll have to see how that plays out a little bit. But I think it's probably fair to say that at least initially the UK is going to be cautious in diverging away from EU law, not least because of these retaliatory measures that I've just mentioned, but it'll be interesting to see how it develops.
Yeah, no, absolutely. So, okay, so in a nutshell, subject to that level playing field point that you've mentioned, EU-derived legislation pre-1st of January is going to continue to bind unless or until the UK Parliament decides to change it, and we won't necessarily be bound by new EU legislation that's introduced after that date. But can we look now, Hugh, at the position as regards EU case law, which has always played, as I said in the introduction, has always played an important role for UK employers? Will the decisions of the CJEU continue to bind the UK courts in any way?
Okay, let's deal with the easy bit first. The UK is no longer bound by CJEU decisions that are made on or after the 1st of January 2021. Although, that said, there is UK legislation which implements the TCA that says UK courts can still have regard to future decisions of the CJEU and may treat them as persuasive in interpreting cases in the UK. So again, it'll be interesting to see what the courts do in relation to taking future CJEU decisions into account.
Okay, and what about CJEU decisions which predate 1st of January 2021? So, for example, some of those holiday pay calculation decisions.
Well, those decisions which predate the 1st of January 2021, and obviously we're including a transition period in that, will continue to bind UK tribunals and courts, although there is a bit of an interesting twist here in that the Court of Appeal and the Supreme Court both have the power to overturn those decisions. Whether or not they do so, we're going to have to wait and see, I think.
Okay, and I think that's interesting, isn't it? Because it started off, it was just going to be the Supreme Court, and then the Court of Appeal was brought within that ability to move away from CJEU case law later down the line. And I think, Hugh, I'm right in saying there's actually very little guidance as to when the Court of Appeal or the Supreme Court might be inclined to move away from CJEU decisions. I think it's limited to where those higher courts feel it is right to do so. So it'll be very interesting to see how quickly those courts decide to depart from the CJEU precedents. One final area, Hugh, that I think is interesting before we wind up our conversation is what the UK government might do within the parameters around level playing field that you've talked about in terms of making changes to workers' rights over time. And in January this year, it looked like the government might be heading that way.
Yeah, you're right. I mean, the previous Business Secretary, Alok Sharma, had planned a review of workers' rights, but recently his successor, Kwasi Kwarteng, confirmed there isn't going to be a review right now. We don't know where that change of heart came from, although you might imagine it's something to do with the challenges of Brexit, COVID, and the risk of Europe seeking to exercise powers under the TCA and a desire perhaps by the government not to be put to the test on that too soon. So that's where we currently stand from the government's point of view.
Yes, interesting. But whilst hearing what you've said on that, if I were to lend you, and it would only be lending you, Hugh, my crystal ball, I'm very fond of it, what employment rights do you think a government in the future might choose to review if they were so minded?
Well, this is perfect territory for a lawyer, isn't it? Because it's complete and utter speculation. So whatever I say can only be right, in which case I will have seen the future, or it'll be wrong, in which case I was guessing. But if you're going to ask me to suggest where there might be areas that the government could look to amend employment law, I mean, uncapped damages for claims of discrimination clearly give uncertainty, financial uncertainty, and make it difficult to assess the risk of litigation for employers, and they would certainly welcome, I think, some kind of cap on that, although of course that's potentially contentious. TUPE, as you've already mentioned, I mean, TUPE is always a target for potential change. One area might be harmonisation of terms and conditions of employment after a TUPE transfer. Currently very difficult to do. That might be something that businesses would welcome. You've touched on holiday pay. Again, that's a complex area which has been driven by European case law. And again, that might be somewhere that the government sought to introduce some kind of simplification to help businesses.
Yeah, good point. So, Hugh, almost time to wrap up, but before we do so, are there any key takeaways you can share with our audience today? I mean, for example, should people be reviewing contracts of employment, for example, or policies?
Usually I tend to finish these conversations with you with a long list of things that people should be doing, but you'll be glad to know this time, I don't think that from an HR perspective right now, the impact of Brexit on employment law means that anything needs to be done. What I think the current position really is for HR professionals is hold on, stay alert to changes that are coming. We haven't had any immediate changes, but things will develop as our relationship with Europe continues to change in the future. So watching brief, I think, really.
Okay, thank you. Thank you, Hugh. You've made those 2,000 pages very clear. And of course, there is the other element to Brexit, which is the new immigration regime, which came in to take account of the fact that freedom of movement had gone. And if you're interested to find out more about that, we've got a guidance note on the Burgess Salmon website, which explains more about those changes. And also, if you have not had enough of me and Hugh, there is a video that we recorded last year, which also runs through those changes, and you can find that on the Burgess Salmon YouTube channel. If we can help you at all in relation to the areas we've discussed today, or indeed in relation to any other employment law or business immigration issues, please do get in touch. Thank you for watching.